Section 274, Modes of winding up. 1. The winding up of a company may be a. By an official liquidation in accordance with the body's Corporate Official Liquidations Act, 1963, Act 180. Or b. By a private liquidation in accordance with this part. 2. The company shall, from the commencement of the winding up, cease to carry on business except so far as may be required for the beneficial winding up of the company, but the corporate state and corporate powers of the company shall continue until the company is dissolved. 3. Where a company is being wound up by way of a private liquidation, any invoice, order or business letter issued by or on behalf of the company or a liquidator of the company or a receiver or manager of a property of the company, which is a document in or on which the name of the company appears, shall contain a statement that the company is being wound up under this part. 4. Where default is made in complying with subsection 3, the company and an officer of the company and a liquidator, receiver or manager that is in default commits an offense and is liable on summary conviction to a fine of not less than 50 penalty units and not more than 100 penalty units. Section 275, Affidavit of Solvency. 1. Where it is proposed to wind up a company by way of a private liquidation, the directors of the company or, in the case of a company having more than 2 directors, the majority of the directors shall, at a meeting of the directors, make an affidavit to the effect that they have made a full inquiry into the affairs of the company, and that, having done so, they have formed the opinion that the company will be able to pay its debts and liabilities in full within a period of not more than 12 months from the commencement of the winding up that may be specified in the affidavit. 2. An affidavit made under subsection 1 does not have effect for the purposes of this Act unless a. It is made within 5 weeks immediately preceding the date of the passage of the resolution for the winding up of the company by way of private liquidation and is delivered to the registrar for registration on or before that date. And b. It embodies a statement of the assets and liabilities of the company at the latest practicable date before the making of the affidavit. 3. A director of a company who makes an affidavit under this section without having reasonable grounds for the opinion that the company will be able to pay its debts and liabilities in full within the period specified in the affidavit, commits an offense and is liable on summary conviction to a fine of not less than 325 penalty units and not more than 750 penalty units or to a term of imprisonment of not less than 6 months and not more than 1 year or to both the imprisonment and the fine. 4. Where the company is wound up in pursuance of the resolution for the winding up of the company by way of private liquidation passed within the period of 5 weeks after the making of the affidavit, but the debts and liabilities of the company are not paid or provided for in full within the period stated in the affidavit, it shall be presumed, until the contrary is proven, that the director did not have reasonable ground for the opinion stated in the affidavit. Section 276, Procedure on Resolution for Liquidation. 1. A company may be wound up by way of private liquidation if a. The company resolves by special resolution that it shall be wound up by way of private liquidation, and b. Before the date of the resolution, an affidavit declaring that the company is solvent is made in accordance with Section 275. 2. The private liquidation commences at the time of the passing of the resolution. 3. Where a company passes a resolution for a private liquidation, the company shall, within 14 days after the passage of the resolution, send to the registrar a copy of the resolution and the registrar shall publish the resolution in the company's bulletin. Section 277, Statements and Accounts of Final Financial Year. 1. For the purposes of sections 127 to 143, the final financial year of a company in liquidation under this part ends immediately before the date of the commencement of the winding up, and, subject to subsection 2, the provisions of those sections shall continue to apply to the preparation, auditing and dispatch of the statements, accounts and reports referred to in those sections. 2. For the purposes of subsection 1. A copy of the documents referred to in Section 128 shall be sent to the liquidator appointed in accordance with Section 278 as well as to every member and debenture holder of the company in accordance with Section 128. And B. A copy of those documents shall be sent to the persons referred to in paragraph A within 3 months after the date of commencement of the winding up. Section 278. Resolution for appointment and removal of liquidator. 1. The resolution for the private liquidation of a company shall include the appointment as liquidator of a person named in the resolution, and the resolution is not valid for the purposes of this part unless the person named has previously consented in writing to the appointment. 2. Where a vacancy occurs by death, resignation, or otherwise in the office of liquidator, the company in general meeting may fill the vacancy, and for that purpose a general meeting may be convened by a member, or if there is more than one liquidator, by the continuing liquidators. 3. The court may, on the application of a member of the company or of the registrar, remove a liquidator and appoint another in the place of the removed liquidator, or appoint a liquidator if, for a sufficient cause, a liquidator is not acting. 4. The company or the court shall give notice to the registrar of the removal or appointment of a liquidator, and the registrar shall register the notice and publish the notice in the company's bulletin. Section 279. Remuneration of liquidator. For the purposes of a private liquidation, the company shall, in general meeting, fix the remuneration to be paid to a liquidator appointed for the purpose of liquidation, and where the appointment of a liquidator is made by the court, the remuneration of the liquidator shall be fixed by the court. Section 280. Disqualification of liquidator. 1. The following persons are not eligible to be appointed or to act as liquidators of a company under this Act. A. An infant. B. A person found by a court of competent jurisdiction to be a person of an unsound mind. C. A body corporate. D. A person convicted, whether in Ghana or elsewhere, of an offense involving fraud or dishonesty, or of an offense in connection with the promotion, formation or management of a body corporate. And E. An undischarged bankrupt or any other person subject to insolvency proceedings under the Insolvency Act, 2006, Act 708. 2. Despite subsection 1, a person convicted of an offense under paragraph D of subsection 1 is eligible to be appointed as a liquidator or to act as a liquidator of a company if 10 years or more have passed since the end of the sentence. 3. A director of a company shall not be eligible for appointment as a liquidator of that company. 4. An auditor of a company shall not be eligible to be appointed as a liquidator in a private liquidation of that company. 5. An appointment made in contravention of this section is void. 6. Where a person named in paragraph A, C, D, or E of subsection 1 or in subsection 2 acts as liquidator of a company, that person commits an offense and is liable on summary conviction to a fine of not less than 325 penalty units and not more than 750 penalty units, or in the case of an individual to a fine of not less than 325 penalty units and not more than 750 penalty units, or to a term of imprisonment of not less than 2 years and not more than 5 years, or to both the fine and the imprisonment. Section 281. Status of liquidator. A liquidator appointed for the purposes of a private liquidation stands in a fiduciary relationship to the company as if that liquidator were a director of the company, and accordingly sections 190 to 217 shall, with the necessary modifications, apply. Section 282. Cessation of powers of directors. On the appointment of a liquidator for the purposes of a private liquidation, the powers of the board of directors shall vest in the liquidator, and the powers and authority of every director shall cease, except in so far as A. The company in general meeting or the liquidator sanctions their continuance, or B. It is necessary to enable the directors to prepare statements and accounts of the company. Section 283. Powers of liquidator. 1. A liquidator in a private liquidation may exercise the power of the liquidator in an official winding up under the body's Corporate, Official Liquidations, Act, 1963, Act 180, and any other relevant enactment. 2. Where several liquidators are appointed, a power given by this Act may be exercised by any one or more of the liquidators as may be determined at the time of their appointment, or, in default of that determination, by a number not less than 2. 3. The court shall have the same powers in relation to the liquidator in a private liquidation as are by the body's Corporate, Official Liquidations, Act, 1963, Act 180, conferred on the court in relation to official liquidation. 4. The liquidator may apply to the court for directions in relation to a matter arising in connection with the performance of the functions of office or to exercise all or any of the powers which the court might exercise if the company were being wound up under the body's Corporate and Official Liquidations, Act, 1963, Act 180, and on that application, the court may give appropriate directions or make an appropriate order. Skip Section 284 and 285. Section 286, Duty of liquidator in case of insolvency. 1. Where in a private liquidation the liquidator is at any time of the opinion that the company may not be able to pay its debts in full within the period stated in the affidavit made under Section 275, the liquidator shall forthwith give notice of that fact, together with a statement of the liabilities and assets of the company to the registrar. 2. The notice and statement shall be in the prescribed form. 3. The registrar, whether or not makes an order under Section 5 of the body's Corporate, Official Liquidations, ACE, 1963, Act 180, shall register both the notice and the statement and cause a copy of the notice to be published in the company's bulletin, and the liquidator shall proceed in the same manner, so far as the provisions are applicable, as a liquidation under an order of the court pursuant to the body's Corporate, Official Liquidations, Act 1963, Act 180. 4. Where the liquidator fails to comply with this section, the liquidator is liable to pay to the registrar an administrative penalty of 750 penalty units. Section 287, Stay of Proceedings. 1. At any time during the course of a private liquidation and before the dissolution of the company in general meeting may, by special resolution, resolve that, subject to the confirmation of the court, the liquidation proceedings shall be stayed. 2. After the passing of the special resolution. A. An application may be made to the court by the liquidator or a member of the company. And B. The court may, and subject to terms and conditions the court deems fit, order that I, the liquidation be stayed, 2. The liquidator be discharged, and 3. The directors be permitted to resume the management of the company. 3. At least 28 days before the hearing of the application under subsection 2, written notice of the application shall be given by the applicant to the registrar, to the directors of the company and to a liquidator of the company, and the registrar shall publish the notice in the company's bulletin. 4. The registrar, a director, liquidator, member or creditor of the company is each entitled to appear on the hearing of the application and to call witnesses and give evidence. 5. Where an order confirming the resolution is made by the court, the company shall send an official copy of the order to the registrar, and the registrar shall register the order and publish a copy in the company's bulletin, and on that publication, the liquidation shall cease and the company shall continue to be a going concern subject to the terms or conditions of the order. Section 288, Dissolution and Restoration of Companies. 1. Where the registrar is satisfied that the winding up of the company is complete, the registrar shall strike the name of the company off the register and publish the record of the strike-off in the company's bulletin. 2. The company is dissolved as at the date of the publication of the notification in the company's bulletin. 3. Where a company is dissolved, the court may A. At any time within 2 years after the date of the dissolution, and B. Upon an application made for the purpose by the registrar or by the liquidator of the company or by a former officer, member, or creditor of the company or a person claiming through or under any of them, make an order, on the terms that the court considers fit, declaring the dissolution void and ordering the name of the company to be restored to the register. 4. An official copy of an order made under subsection 3 shall be delivered to the registrar for registration, and the registrar shall publish the copy of the order in the company's bulletin, and the name of the company shall be restored to the register. 5. Where registration and publication under subsection 3 takes effect, the company shall be deemed to have continued in existence as if it had not been dissolved, and for the purposes of a period of limitation the period between dissolution and restoration shall not be counted. 6. The court may by the order give the directions and make the provisions that seem just for placing the company and any other person in the same position as nearly as may be as if the name of the company had never been struck off. Section 289. Dissolution without full winding up. 1. Where the registrar, by reference to personal knowledge, or on information supplied by any officer, member, or creditor of a company, has reasonable cause to believe that the company is not carrying on business or is not in operation, the registrar may by written communication to the company inquire whether the company is carrying on business or is in operation. 2. Where the registrar does not receive an answer to the written communication, within 2 months of the communication, the registrar may send to the company a second written communication referring to the first written communication, stating that an answer has not been received by the registrar, and that if an answer is not received to the second written communication within 2 months from the date of the second written communication, a notice will be published in the company's bulletin with a view to striking the name of the company off the register. 3. Where the registrar receives an answer from the company to the effect that it is not carrying on business or in operation, or does not within the specified time after sending the second written communication receive an answer to the second written communication, the registrar may publish in the company's bulletin and send to the company by written communication a notice that at the expiration of 3 months from the date of that notice the name of the company shall, unless cause is shown to the contrary, be struck off the register and the company shall stand dissolved. 4. Where a company is being wound up and the registrar has reasonable cause to believe that a liquidator is acting but is not satisfied that the winding up is complete, the registrar may publish in the company's bulletin and send to the company and to the last known place of business of the person last known to have acted as liquidator, a notice as is provided in subsection 3. 5. At or after the expiration of the time specified in the notice, the registrar shall, unless cause is shown, strike the name of the company off the register and shall publish the notice of that fact in the company's bulletin, and on that publication in the company's bulletin the company shall stand dissolved. 6. For the purposes of subsection 5, the liability of every director or other officer and member of the company shall continue and may be enforced as if the company had not been dissolved, but the subsection does not affect the power of the court to order the winding up of the company. 7. When the name of a company is struck off the register under this section, at any time within 12 years after the publication in the company's bulletin in accordance with subsection 5, the court may, on application made for this purpose by a liquidator or by a former officer, member or creditor of the company, or by a person claiming through or under any of them, make an order on the terms that the court considers fit, declaring the dissolution void and ordering the name of the company to be restored to the register, and subsection 3 shall apply as if the order was one made under this section. 8. A notice or written communication to be sent under this section to a company A. May be addressed to I. The company at the registered office of the company, 2. A company at the last known place of business of the company if an office has not been registered, or 3. The care of an officer of the company. Or B. May be sent to the person or each of the persons who subscribe to the incorporation of the company addressed to that person at the address mentioned in the subscription to the incorporation of the company, or to the registrar if there is no officer of the company whose name and address are known.